the court said. The court has been absolutely clear that it will exercise review jurisdiction if there's insufficient evidence, if there's no evidence, if there's absence of jurisdiction, if there's malice of facts and law. All of the underlying convictions and sentences were set aside for insufficiency of evidence. Orders were granted for release. The matter is subject to appeal. Concluding observations. I'm reminded that, of course, the supervisory body in Pakistan is no different from my supervisory body, the Bar Council of England and Wales. It's the Pakistan Bar Council that has disciplinary function, not the Lahore High Court Bar Association. But it shows you how desperate India is, that its reference for institutional bias it finds in the utterance, which isn't accepted in any event, of an individual who occupies the modest role of a secretary of a provincial bar association. Now that tells you a lot with respect. Concluding observations, Mr. President. Thank you for your indulgence in wanting me, in providing me with the opportunity to go a little over 1 o'clock, but I doubt I will. I have 9 points to make by way of conclusion. And again, I make them in the light of the observations I made right at the outset. The court has my detailed written submissions. The court has this document before it in the judge's bundle with the references. And I say unhesitatingly, based upon the evidence, as follows. First, India's application should be declared inadmissible. I appreciate this is the first time this is going to happen, but sadly there's a first for everything. But we have to thank India for that, because India is the first state to come before this court to abandon studied ambiguity and in its breathtaking arrogance to try to continue to persuade the court that the evidence that is before the court is concocted. It's a litany of false allegations. Well, it isn't. And it's not good enough to keep on invoking the same mantra of concoction, irrelevance, propaganda. The burden of proof shifted to India. That burden has not been discharged. As a consequence, the evidence before the court, sadly, manifests abuse of rights, lack of good faith, illegality, lack of clean hands, and misrepresentation. Any one of those would militate against relief. All of them together, not least those brazen attempts during the course of these proceedings to doctor the military experts' reports, to engage in linguistic contortions so as to wish away the 2008 agreement, and this ridiculous document, headed secret, 7-page memo, which couldn't possibly have been created on the 26th of December, all to try and persuade this court of the position of India, taken together, requires this court, with respect, to declare the application inadmissible, or militates against the grant of any relief. Third, the Vienna Convention on Consular Relations is not engaged, as India has not established, for its own reasons, that Commander Jadhav is an Indian national, nor was consular access refused prior to commencement of these proceedings. Customary international law provided for an exception to consular access in the case of an individual reasonably suspected of espionage, not suspected on the basis of manufactured evidence. This remained unaffected by the VCCR. Fifth point, even if the VCCR was engaged, India's conduct in sending Commander Jadhav to engage in acts of espionage cannot but constitute a brazen, blatant violation of Article 5A, a violation of international law, as well as Article 55, non-interference in internal relations of a state. The absurd proposition that's being advanced is officials who have diplomatic immunity ought to be able to go and see Commander Jadhav, to glean from him which of their assets, their tools of terror are still safe, and be able to continue with impunity until they're declared persona non grata. That isn't what the Vienna Convention was intended for, as Grigory, Tunkin, and others pointed out in 1960. And to allow that to happen in this case would provide a fundamental obstacle to the pursuit of the objective of the Vienna Convention on Consular Relations, namely the promotion of friendly relations between states. A red line exists, and that red line has to be shown in clear and simple terms. Sixth point, further in the alternative. India and Pakistan entered into a clearly worded agreement on consular access, operative in material terms since 1982, and amended in 2008. Which identified the basis upon which consular access would be considered in the case of an individual reasonably suspected of espionage. The said agreement, at Article 6, must be given legal effect in accordance with its plain and ordinary meaning. And objective. It's not suggested that India and Pakistan haven't applied the agreement for decades. I respectfully submit it's perfectly consistent with the VCCR. Either because it amplifies the terms between the two states, or because it elaborates how they will deal with espionage cases in the context of the absence of any customary international law requirement to provide consular access in such cases. Seventh point, India's claim, which it continues to persist in, for at least, goodness knows what more they want, beyond acquittal, release, return, annulment of the conviction is being charitable to India yet again, misconceived, being more realistic, at worst, made in bad faith, in the light of the court's previous decisions, consistently rejecting such a claim. And there's a reason why, and I'll come to it with my final point. Because India has made no other claim for relief. And therefore, if it's all or nothing strategy fails, it should not be entitled to relief. Penultimately, even if the court were to hold that the Vienna Convention on Consular Relations, Article 36 engaged, and a right to consular access was denied, the appropriate remedy is amply provided for by effective review and reconsideration before the Pakistani High Court, in accordance with Article 199 of the Constitution of Pakistan. This remedy has been available to Commander Jadhav and his family at all material times since his conviction. And that is an important point, because India has studiously avoided invoking this. India, Commander Jadhav's family, have not invoked this. It was open to them to do so after the 10th of April 2017. Why not? And I come back to the point that I made before this court on the 15th of May 2017. This case is not about consular access. This case has at all material times, I'm sorry to say, been political theatre, grandstanding, a platform for India to engage in rhetoric. This incarnation of India, I'm sorry to say, not the India that I'm familiar with. And as such, it's an impermissible use of this court. The court can be confident that Commander Jadhav has the entitlement that, even if the Vienna Convention was engaged, would otherwise flow. And it's vital for the rule of law, not least in these times, for the court to review the conduct of India for what it is. And I invite the court to dismiss the application of India accordingly. Thank you, Mr. President.
I thank Mr. Qureshi. Your statement brings to an end today's sitting. Oral argument in the case will resume